period, and yet we have yet another change in which many businesses found themselves taxed at over 100% of their revenues due to various quirks in the tax laws, including one that many of what we would call ordinary and necessary business expenses weren't deductible, and where various complex currency controls existed, so that in many lines of business it again became impossible to do business while obeying the law and paying your taxes and complying, if you're an international business, with currency controls. I think a very important reform during the early Putin years was a lowering of taxes and a tightening of some other legislation. And I think for the first time it really made it possible to do business in many areas while obeying the law, with the minor exception of what is sometimes called grease. As you know, the U.S. law on anti-bribery law says it's okay to make routine payments to get lower-level officials to do their job. And that is a problem in many countries in the world. But aside from that grease, I think by 2000, 2001, it became possible to do business while obeying the law. On the other hand, you have, by that point, 75 years of tradition of doing business while disobeying either statute law or moral law. So one could not expect people to immediately convert. I think one thing that has caused some conversions is not preaching, but more efficient tax enforcement, brought about in part by technical assistance from the U.S. Internal Revenue Service, the greatest experts at that. But I think the temptation remains, particularly for many businesses that had set up highly efficient structures for avoiding and evading the law, and businesses which had very smooth channels for getting things done. I remember one business man complaining to me that somebody by mistake had shipped him some goods through St. Petersburg instead of through Moscow, and his man in customs was in Moscow, and causing immense difficulties. So I think all this is just going to take a very long period of time for those old habits to change, even though I think increasingly in many areas it's possible to be quite legal.
Thank you. Thank you. That's I don't know, is that optimistic or pragmatic?
It's realistic.
Realistic, that's what we'll call it. Okay, Oksana, we'll continue on.
Okay, thank you. It's an honor and a pleasure for me to share with you my views and my concerns on the possibility of obeying the law in Russia and still keeping quite well. Maybe the difference of my view and of my colleagues here sitting today with me is that I'm looking on the situation a bit more from inside than from outside, being a Russian lawyer by education, by tradition, and by working in Russian legal system now. Peter didn't dare to go deep into history, and maybe I would say a few words. Before the 1917, before the revolution in Russia, there was a very good and long keep tradition of doing business, not maybe in the terms of obeying or not obeying the law, but in the terms of doing it honestly. And if someone was breaking the word given to the other party of the contract, it was considered immoral. So the business in Russia in the 18th, 19th centuries was kept not only and not mainly in the tradition of obeying the law, but in tradition of keeping it honestly, in the moral tradition. Of course, the situation has changed greatly through all these periods of time when there was no business, when it was impossible to obey laws, and now the general idea of necessity of obeying the law is coming into the mind of people in Russia once again. But the first question that arises for me as the lawyer who is mainly involved in drafting of the legislation is the quality of the legislation that we have to obey that is to be obeyed. And what can I say? That the substantial law shall be clear, non-contradictory, and it shall adequately reply to the economic and even social concerns. In this case, the obeyance of this law will be logical and easy. The Russian legislation that regulates business relations now is at least modern, and to a big extent it complies with these requirements. But still, the lack of coherence is one of the real problems of Russian legislation now. Until recently, the situation was quite often that if you obey one of the legislative provisions, you will not be able to comply with the other one. And we may still find some examples of such situation now, though they are not so numerous, but still they exist. For example, in the sphere that I am interested in the sphere of immovable property, when you apply to registration of immovable property rights, you have to obtain so many particular documents required for registration, and the time period for their validity is so short that while obtaining some of them, you will keep these documents, and you'll spend so much time that the period established for the validity of some of them will pass for sure, and you'll have to start it again. Otherwise, you'll have to look for steps that will help you to have a shortcut, and not all the methods that you use there will be legal for sure. So there are still some situations when you cannot obey all the legislation at a time. And then the other problem is the constant modernization of our legislation, because in case of Russia, this constant modernization of legislation doesn't always lead to reduction of inconsistencies. It, from time to time, it even produces more of inconsistencies. The good example is the land code, which was worked out for 7 years. Then it was adopted in 2001, and it even increased the number of contradictions in the sphere of regulation of land transactions between the civil code and the land legislation. Before that, the civil code was the act of the higher judicial force, and the land legislation mainly was of the lower level of legislation. And now, having two codes with the different provisions, it's very difficult for business persons to obey both of them at a time. Then again, the difficulties may arise having in mind these numerous administrative reforms of the latest years, as well as the judicial reform. It also leads to constant modernization of legislation, and unfortunately not all the reforms of such kind are well planned in advance. And this positive effect of the reforms is to a big extent lessened by this necessity to make additional changes to the newly enacted rules. And as a result, the business community doesn't have enough time to get used to these regulations, and they are already changed, and they have to get used to the new ones, and it's absolutely impossible to predict what is going to be changed in the legislation. So these changes make very difficult the necessity to plan activities in accordance with this legislation that can be changed every minute. It is one side of the problem, as I see, and the other one is what kind of business can be held in accordance with law, what kind of business can easily obey the law, and what kind of business, according to its substance, has the problems in obeying of the law. When we ask ourselves, is there anybody in Russia who obeys the law? The answer will be definitely positive. But the examples of those activities that can quite easily obey the law, they will be the legal advice, the financial advice, auditing activity, publishing activity, and some others of this kind. But if we turn to the activities where the activity presupposes extreme profitability, for example, the natural resources extraction or energy supply, the risk of disobeying the law is much bigger. It is already in the substance of the business itself. So if we speak about the first group of the activities, we can say that there still remains the danger of disobedience of a law in the sphere of tax legislation, because the taxation optimization may easily change and become a breach of tax law. And the main approach of the state to this group of companies, it seems to me, shall be that the efforts shall be taken not on changes of the rules of the game, but on implementing the existing legislation and on control and supervision functions of the state. But as to the second group of the companies which I was speaking above, on the contrary, the serious changes of legislation is still necessary, because it's absolutely necessary to provide the mechanisms that will not allow the possibilities of influencing the decisions of state bodies while they exercise control over these areas. And the most obvious example will be the subsoil legislation here, because the mechanisms of access to natural resources shall be such transparent and such reasonable that there will be no real possibilities of people to influence on making of the decisions. And now some attempts are made to change their legislation on subsoil to the formula. Then all the access to the natural resources will be given through public auctions. At least they will give enough transparency, and maybe it will help the investors in this sphere and the business community to be sure that the obedience of laws in this sphere will be much easier. And the last point that I would like to stress is the one that the carrying business effectively and honestly in Russia is possible only if the business is sure that it can obtain the adequate system of dispute resolutions. It was much told about this aspect of business held in Russia today. So I will not again stress your attention to the problems of corruption or fair dispute resolution. I would like to raise the question of highly professional judges, because if you want to have the good working system of dispute resolution, we have to have them not only uncorrupted, but we have to have the judges highly professional. And in this respect, I would say it's really very important that all the decisions of the arbitrage courts, at least from the level of federal district courts, shall be published. It's not a secret that now the professional skills of judges differ greatly from person to person, from region to region. And in this respect, the publication of the decisions of the courts, it will be not only of educational value and not only for the judges of educational value, it also be very important for them to unificate their attitude to the disputes of the same kind. I am not so optimistic to believe that this can be done free of charge. For sure, someone will have to pay for this. Hundreds and of thousands of decisions of the numerous arbitration courts through the whole Russia that are passed every year. If we want to see them all published, it will be done either through the legal magazines or through some computer systems, and someone will have to pay, either the users or the government or maybe both. But this is so important possibility of educational and of moral even importance that the possibility of having all these decisions published is worth paying for it. And I think I will stop on this. Thank you.
Well, thank you very much, Oksana. I think the questions of transparency and certainly predictability, as you suggest, are critical ones for businesses. So let me now turn to Peter Solomon, get his thoughts.
Thanks, Kathy. Well, first of all, I really appreciate what Oksana has said about the importance of the actual state of the law or the laws themselves, that you can't obey the law if the law is incoherent and full of contradictions, or if it's constantly changing and you don't know what the laws are. But as you'll see, the remarks that I prepared connect to what some of the things that Peter said. Now, the question, let me repeat again, is can businesses survive in Russia if they obey the law? In one sentence, I would say, sometimes, but not always, and more often than a decade ago, but only if business people also observe the informal rules and, when appropriate, cooperate with political power.
That's quite a sentence.
How about that? Do you think so now a bit of gloss.
We'd almost think you were a lawyer.
That's the influence here. Okay. Well, informal institutions or practices are crucial, but themselves subject to change. In Russia today, it often remains necessary to pay for protection, for krisha, which Louise was talking about this morning. But by now, many firms are no longer paying criminals under the table, as they did in the mid-1990s, but rather hire firms that offer this service legally, perhaps staffed by former KGB or FSB officials, or even hire public police, the ordinary police, who now spend a good part of their actual job hours doing contract work. And there's very interesting sociological studies done by Russian sociologists on this. Successful firms may also be asked to share their profits with powerful people. Whereas in the past, this often meant criminal groups pushing their way in, I think this phenomenon has become less common with time. But what does continue, I think, is the need to find ways to reward politicians and governmental officials who help the firm through facilitating licenses, granting special deals, or ensuring favorable legislation. Insider deals, corruption, conflict of interest remain commonplace, but they do not always mean breaking laws. The laws may even facilitate such arrangements. And again, I think Peter indicated that, the lack of a law on corruption, the weakness of conflict of interest provisions is problematic. Where the stakes are largest, for example, with natural resources, such as oil and gas, cooperation with the highest level politicians is necessary. And failure to meet expectations may end in dire consequences, as Mr. Khodorkovsky has learned. Apart from these larger structural arrangements, the conduct of business for firms of any size is likely to require involvement in petty corruption. Again, something Peter alluded to. Paying what amounts to service fees is obligatory in many contexts. For example, to get prompt service in obtaining licenses or other necessary documents from government agencies. Sometimes firms will even pay courts to ensure that their claims are heard in a timely fashion. Now, I agree with Peter about my next point concerns tax reform, and I think it's vital. I think tax reform, especially the law of 2001, has most likely cut down on illegal activities by firms, and there's evidence that at least the owners of small firms would like to operate within the law. The remaking of the tax system has produced a situation where the overall obligations of many firms are reduced to levels that are manageable, and that in turn improves the collection of taxes. At the same time, it makes it possible for firms to stop such common illegal practices as hiding assets or keeping a share of their employees off the books to avoid paying social benefits. The anthropologist Caroline Humphrey has found, both among small business players in particular, both the desire for what she calls a normal life and the dream of law. That is, that these people really would prefer to play by the rules and not exist with the tension and strain that goes with not doing so. Her work suggests that, given the opportunity, many, if not most, business people in Russia would operate within the law. I think it's important also to pose the reverse question, namely, to what extent business firms use the law or laws to serve their purposes, and more generally see laws and courts as resources for the pursuit of their interests. And here I'm going to connect to some of Kathy's work. The ever-increasing volume of suits and complaints brought to the arbitrage courts stand as testimony to a growing awareness among business people of the utility of law, as does the tendency for major business interests to have allies within the legislatures, whether as deputies or staff. At the same time, Russian firms have learned how to use laws designated to serve the public interest, such as on bankruptcy or corporate governance, to serve narrow private interests, specifically hostile takeovers of competitors. Vadim Volkov has written brilliantly on this phenomenon, a phenomenon that was prevalent especially between 1998 and 2002, before the bankruptcy laws were reformed. In using these laws for hostile takeovers, firms might well engage in fraudulent acts, but often unethical manipulation of the laws, I think, did not involve actual violations of them. Finally, the degree of law-abiding conduct on the part of firms in the Russian Federation is bound to vary with the sector, as Oksana was suggesting, with the geographical location of the firm, and with its financial strength. For it is these factors that determine the nature of the informal rules and practices to which the firms must adjust, and the degree to which observing important informal rules requires contravening formal law. To a degree, businesses will have to engage in forms of corruption until the public service itself has changed, so that making a career in government calls for the abandonment of unfair favoring of friends, and a true civil service emerges.
Well, you see how scary I am, because everybody complied with their time limits. So,
Absolutely.
So now we have lots of time to learn from the wisdom in the room. I'm not sure that we can imagine an assembly of people that know more about the questions of law in Russia than the people we have in the audience here. So please let me ask you to pose questions, to make comments, to add to our discussion here. And if you could identify yourself so everybody knows who everybody is.
Bill Burnham from Wayne State University. Did Khodorkovsky do it?
So shall we answer that up here, or does someone in the audience want to respond to that?
Do you want to do a show of hands?
Yeah, should we have a show of hands?
Maybe we shall wait for the final court decision, then we'll know the answer.
Yes, that's a good answer.
Unique method.
I like
Not really
that
the
method.
Russian method, though, huh?
It's not the Russian method, but I remember the old joke about the umpire. One of them says about calling strikes. He says, "I call them as I see them." The next one says, no, I call them as they are. And the third one says, they're nothing until I call them.
That's right.
Yeah. So, are there people that would like to comment on the Khodorkovsky situation? I find this hard to believe. I'm a law professor. I will call on people.
I'll make a brief comment. Some time ago, maybe a year ago, I went to a presentation by a very knowledgeable person. I think the presentation was sponsored by Liberty Radio Free Europe, I don't know who gave it, who explained the Appetit fertilizer transaction that was at the center at that time of the criminal charges. I have never seen such a mind-boggling transaction, let alone decide whether something was done illegal. Even after an hour-and-a-half long brilliant explanation, I didn't even understand what happened, which makes the case a very difficult one.
I agree with Peter. I mean, I think you've got the problem. And it touches what Oksana said too. This case connects to the period when the laws were unclear, contradictory, and so that a judge indeed probably has that term we were using earlier, a lot of discretion to decide what, in fact, is legal and what is not legal, in addition to what's actually involved in the case.
Other questions? Did you want gentleman down front here?
Leonard Oberlander. When there is a question of financial obligation of a Russian corporation, a Russian company, to a foreign company, and when a private Russian company has its shares 100% owned by the government, where is the final legal accountability resting? Is it with the company, or is it with the ministry, or where?
Legally with the company.
But is it a private company?
It's a private company owned by government. But
If the
still,
government
according
owns
to our
the
laws,
stock, yes. If it is a state enterprise, the rule can be quite different, because the government in some cases may be responsible for the debt of a state enterprise, which is organized as a state enterprise, not as a stock company. If it's a stock company, it's like any other stock company. It doesn't matter who the shareholders are. You're owed money by the company.
Yeah. Joe, Will had a question.
Will Pomeranz. Just to follow up on the whole Khodorkovsky issue, kind of not dealing with the ultimate guilt or not, but from your perspective, where does this leave the reform of the Russian criminal procedural code? I mean, it's been just trampled on throughout the entire Khodorkovsky case in terms of the rights of the advocates, the right of them to visit their client, their searches. I think 2 of them are living in America now because they can't go back to Russia. From your perspective, what has the Yukos case done to the reform of the criminal procedure code, which was so important when it was passed in, I think, 2002?
Well, I think I think this is a special case. And indeed, I mean, I would almost reverse the arrows. It is the trampling on so many provisions of the new code that suggests that the players involved are, if not frightened, leaning over backwards to be sure that they are pleasing their masters, whoever they are, wherever they might be. No, there's that term that's entered, common speech in Russia now, basmanное правосудие, the administration of justice, Basmani style. Basmani is the name of a particular court in Moscow, and it is the court that happened to hear the first part of the Khodorkovsky criminal case, not the substance, but just the pretrial detention part. And that term has actually become sort of now stands for sort of routine violations of the of criminal procedure. And there's actually a wonderful book that was put together by Katerina Moskalenko and some of her graduate students who did some field work. They went and sat in trials at the court and tried to make a count of all the violations. And but what's interesting is if you read that Basmanное правосудие book, what you find is that what they're talking about happening all the time are really very trivial things. That is, for example, that the prosecutor often meets with the judge privately at the beginning of the trial for a little conference. And you might say, my gosh, what's going on? Why is this prosecutor telling the judge what to do? No, it's exactly the other way around, actually. The prosecutors are unprepared often, and the judge is trying to coach the prosecutor so the trial will come out reasonably. But in any case, it's a series of things on that level. At the very end of the book consists of a series of newspaper articles that were dealing with the Khodorkovsky case, and the violations there are of a different order. So you see, you have this contrast between routine violations, which are, part of the struggle to make criminal procedure work, and the more glaring sorts of things that have become part of that case. To me, a little bit, I was a little surprised, actually, because you'd think if it's an important case that's under the glare of Western public opinion, maybe they would have worked harder to observe the rules, but that did not happen.
But I think this goes to something that I think both of us have written about, and to something that goes back to an article that Bob Charlotte wrote many years ago about the dualism of Soviet law, and perhaps what we're seeing, and I think we are seeing, is an emerging dualism in post-Soviet law and Russian law, that we can find these exceptional cases, and exceptional in not a positive way, but where the rules are being routinely violated. But is that the way we should characterize the system? Which is, and the question is, which is swallowing which?
You can say the same thing about Tsarist courts as well, by the way. All these special military tribunals in Tsarist Russia where they try political criminals.
Well, some might argue you could say the same thing about the American courts, too.
Yes, exactly.
Yeah, that it's not something that's really unique to Russia. Yeah. So Harley had a question.
I'm Harley Balzer from Georgetown University. I suppose if you had read President Putin's Kandidat dissertation, Khodorkovsky's fate would not surprise anyone. But I guess two questions about it. One, Peter, you said this is an exceptional case. It's a special circumstance. There have been some articles in the Russian press suggesting that at the local level, there are beginning to be a growing number of exceptional cases also, that the behavior is being imitated. And I'm wondering whether any of the panel members have seen some of this in the last year or two. That is, the signal has been given that you can make exceptions for particularly bothersome or wealthy targets, and therefore that behavior is being replicated. And also, there was some discussion shortly after the Khodorkovsky case began about defining the tax laws so that a business that used tax law simply to evade taxes rather than for business purposes would be liable for the back taxes, which sounded to me like a legal morass of unbelievable proportions. And I don't know if this was just something that the press picked up on that went away, or whether this has started to be a problem.
Can I make a couple of comments?
Sure, absolutely.
First of all, I think we need to send Kathy back to hang out in the criminal courts instead of the arbitrage courts so we can get some real statistics on this. I am reminded about
you don't like me, do you, Peter?
Russian plea in the Kalashnikov case. Kalashnikov was not the guy who invented the gun and is now a wealthy arms sales consultant. It was some poor guy who was held in truly horrible conditions in pretrial detention, and who became the first Russian to win a case against the Russian government in the European Court of Human Rights. The Russian government spokesman offered the defense that he was treated just the way they treat all their pretrial detention prisoners. And there was considerable evidence that this was true. And so I think we know that Khodorkovsky has much better public relations for bringing violations of criminal procedure to the attention of the press than any other Russian person undergoing a trial today. I think it's very difficult without some of this good empirical research to know just what is actually going on.
Did you want to speak to the tax issue?
Oh, on the tax issue, I think Russia inevitably will move toward principles adopted long ago by the United States tax authorities, such as if you didn't have a business purpose, we're going to disallow whatever arrangement there was, such as the step transaction rule. If you go from A to B and B to C, if it would make you pay more taxes, we'll treat you as you went from A to C, such as the statute of limitations never runs if you have concealed things. So I think every country has to move in that direction, because otherwise very clever people will use these loopholes. So the question more is just how you move in that direction, and whether you do it by statute, court decision, or what. And that gets to be a very complex question.
Are they going to apply these retroactively?
Well, those are the
Harley's
sort of
question.
questions that become interesting, but I think Russia inevitably has to move to all those rules we have had for decades in the United States, because we have had many decades more of clever tax lawyers.
Right. Oksana, did you want to add anything to this?
No, I think
Okay. Peter, did you?
No,
we have many questions.
I'm okay.
Peter Juvler, you've been waiting for a while. You had a question before?
Just a very brief question for you, my ears. Thank you. My question was whether, given the unevenness and in some ways unpredictability and vulnerability of judicial decisions and general state legal profession conduct and just generally those issues, is there emerging anything equivalent to, or maybe going beyond, what was at least a pre-revolutionary sense of a corporate legal profession, which at its best was one of the world's best? And whether there is any fiduciary or organizational initiative that might create some motion within the bar, that it has a real meaning for honest and consistent application of the law, so that there becomes more unity, for example, between the Constitutional Court and the other courts. I think you talked about the Constitutional Court this morning, but what is your view on that background issue of the corporate identity and fiduciary activity of the legal profession itself?
Go ahead.
Well, I think this is something where there's a real dividing line between Moscow, Petersburg, and then the rest of the country in terms of the development of a corporate bar. That we know that Russia has a divided legal profession, and so we have advokati and then we have yuristi. And as part of this survey that I was talking about before, we examined what was going on with the legal departments of enterprises. And what was interesting is that they were shut out of the loop on many important issues. For the most part, the legal departments did not play an active role in privatization. They do not play an active role in commercial paper kinds of issues. And so it's been interesting to me that they have, and part of the answer, I think, is that they don't really have a strong professional identity. Now, Louise, you did some work on this during the Soviet period, and when I was reading your book, it seemed like they're so disparate. They don't really have a chance to talk to each other. And so the question of whether or not a corporate bar, like we think of it in terms of people that practice in large law firms, which is clearly emerging in Moscow and Petersburg. And when I do sit in the arbitrage courts, the quality of lawyering that I see in Moscow and Petersburg and then elsewhere is just night and day, right? And so, but I don't get any sense of fiduciary duty on the part of lawyers. But maybe others have different impressions. But I think what's interesting is how the corporate bar is going to reemerge, in what form, and how are they going to find their professional identity, because they don't really have an organization that you don't pay dues, you don't go to meetings, that kind of thing. They're just sort of spread out and therefore atomistic.
I mean, there is a national advocatura now, but but I know it's not. I mean, and that's part of the problem. I mean, that is to say, the defense bar at least now has a national organization and coherence. But what Kathy's saying is, of course, the advocates are a small part of the legal professionals.
One more comment. If you look at the information on the fate of minority religious communities, especially in the periphery, in the provinces, and the partnership between, say, the local Russian Orthodox Church and the law enforcement, then it would seem that even in areas of property law and also civil rights, such as meetings, conduct religious freedom, etc., that there's a tremendous amount of misinterpretation or misapplication of the 1997 Russian law on religious freedom. There's a whole lot going on that is immensely violated of religious freedom, and that might be an area also, which it does involve property too, and that might be part of an area to look at and maybe to push the local associations on.
Right, but it sounds like
is that correct, by the way? That's my impression.
Yeah, I think that's correct. But what you're talking about is we're moving back into the advocatura, because a lot of the lawyers that will be representing them, of course, would be more part of the advocatura than part of this corporate law bar. But both, I think that the advocatura is sort of finding its feet with the new law, and tried really to flex its muscles in the corporate area by outlawing juristi from representing clients in front of arbitrage courts. Now, they were slapped down on that by the Constitutional Court, and now it's open to anybody again. But I think they're really flexing their muscles.
And yet another case of overreaching by the Constitutional Court.
If we want to say that.
Yes.
Illini doctorate. I refer to the fact that in March 2005, there was a conference on tax crimes in Moscow. And it points out that Khodorkovsky-type cases, in other words, criminal charges over tax avoidance, there are 1,194 in the courts. This is not an isolated type of case. And the earlier articles pointed out that the tax code, which has the loopholes that we in the West would recognize for transfer, middleman payments in oil, and these things, some of which Khodorkovsky says I'm legitimate on, and my company's legitimate on, these would be settled perhaps in a tax court in the United States, but there are no tax courts, nothing to handle this type of thing, that the only way to act is through criminal charges, and so on. And this issue, which again I refer to the article which I picked up in the World News Connection last Monday, no, not today, it was a week ago, points out that there is a problem here. It's also a problem with how do you respect middlemen, which is part of the Russian tradition. So there is a fundamental issue here. What is tax avoidance? What is tax evasion? And so on. And the suggestion by one Russian legal expert and others is maybe we need to go to a tax resolution system which is developed in other countries before we have the only option, which is bringing criminal charges.
Well, first of all, there are a great many civil tax disputes in the arbitrage courts, which, as Kathy said, a very high percentage of them the taxpayer wins. And some of these concern nickels and dimes, but others concern very large sums of money where the taxpayer is a good lawyer. I think there is a problem, given the complexity of the tax code and the complexity of big company accounting, that maybe one should think of having a specialized tax court for these civil cases rather than just because some big company happens to have its seat out in some distant province hitting some poor provincial judge with this. That's another issue. The criminal cases, I think, are really a different issue, and the...
Before you go on to this, can I just say something?
Yeah.
I just wanted to make everybody aware that, of course, within arbitrage courts, and I think within the courts of general jurisdiction as well, there's a tremendous amount of specialization, so that you would have the same judge, the same set of judges that are handling all tax cases. And so even if you're in a provincial court, I mean, Moscow would have people that are truly expert on this, and even in a provincial court, you would have someone who, on a daily matter, deals with tax cases. So in essence, there is a tax court. It's just embedded in the arbitrage court.
But of course, if it's big money, it gets appealed to a more generalist court. And if it's big money, it's going to get... But even then, there may be some...
There would be specialists.
Yeah. The other point is just a technical point. In the Khodorkovsky case, the tax charges didn't appear till rather late in the day. The original prosecution had to do with a privatization that was alleged to be illegal.
Yeah. I wanted to add that I wouldn't be so enthusiastic with the idea of specialized courts, because the history of Russia shows that all these specialized courts are quite soon becoming the courts of concrete vedomstva attached to this governmental agency and protecting its interests. So I wouldn't say that, at least for these years, it will be the good solving of the problem of taxation.
Yes, I have an impression which I think you may not want to leave, which is that you see the Khodorkovsky case or matter sort of as independent of politics. Now, you have Gusinski, you have Berezovsky, who decided in both cases to leave. Sasha Nikitin, before he was acquitted, was offered to go to Canada along with his family before finally the Yeltsin-era court decided to acquit him. What is amazing about the Khodorkovsky case is that he is willing to sit it out. And part of the reason may be that he has compromised on many people in the Russian government. And so that's why he is in the equivalent of a country club jail as opposed to a jail where he may get typhus or something else. But one thing which I think is important to note, and I would like reaction to this, Russia only a couple of years ago came up with laws on transfer pricing. And so that, there's the old Michael Kinsley quote, which is the crime is not what's illegal, the crime is what's legal. And so a lot of what's happening is that there's sort of a moral judgment being made with response to Khodorkovsky, which has no basis in law.
Yeah, I think the point that at least I know I was trying to make is not that politics are not involved, but just whether this is typical, how typical this is, how much we can generalize from one case. I don't think any of us would say that there's not politics involved in the Khodorkovsky case, and so I don't know that we disagree, but I'll let others speak to that.
You have a...
Спасибо. Я хотел задать один довольно простой вопрос.
I would like to ask one simple question.
Сегодня в нашем законодательстве для того, чтобы признать недействительным договор, который противоречит закону, существует срок в 3 года.
Today, according to our law, to invalidate a contract, it takes 3 years.
There's a statute of limitations of 3
Oh,
years.
the statute of limitation.
Но для договоров, сделок, которые заключены с помощью обмана, преступления, существует срок 10 лет.
But the statute of limitations is 10 years for contracts involving fraud or any other crime.
Месяц тому назад состоялась встреча президента с самыми богатыми людьми России.
A month ago, the president met the richest people in Russia.
И президент пообещал им, что он внесет в Думу закон, по которому этот срок в 10 лет для сделок приватизации будет сокращен.
And the president promised to those people that he is going to sponsor a law in the Gosduma in order to reduce that statute of limitation for privatization transactions.
Все эти люди ушли страшно веселые и довольные.
All those people were greatly emboldened by that promise.
Почему они так обрадовались? Почему у них были такие довольные?
I wonder why they were so emboldened, why they were so joyful.
Если они ведут честный бизнес, если они никогда ничего не нарушали,
If they run honest businesses, if they were never in violation of the law,
вообще мне кажется, что сама постановка вопроса, который мы обсуждаем, она предполагает в качестве исходной позиции, что бизнес всегда предстает в розовых одеждах, и только плохое государство, которое его душит.
in general, I think that the premise of this discussion is that business is always angelic, and it's only the bad guy is always the government that tries to suffocate business.
Я в связи с этим вспоминаю, как мы готовили гражданский кодекс, главу о страховании.
I remember when we were preparing the civil code, I recall the chapter on insurance.
К нам приехал консультант из Соединенных Штатов, из Калифорнии. Я не помню его фамилию сейчас, профессор.
We entertained an American advisor who was a professor and from California, an expert in insurance.
И привез 5-томное издание калифорнийских законов о страховании.
And he brought along 5 volumes of the California laws on insurance.
И когда мы его спросили, неужели у вас столько законов? У нас их всего пока вот только всего тоненькая папочка.
So we wondered whether or not the Californians have indeed so many laws, while we only had a thin, skinny folder.
Он сказал, очень просто. Мы издали один закон, страховщики его нарушили.
Well, he said, it's very simple. We issued one law, the insurance people violated that law.
Мы издали другой, чтобы предотвратить эти нарушения, страховщики нашли другие лазейки.
We issued another law to forestall those violations. The insurance people found another loophole.
если вы мне не верите, вы можете сами найти это пятитомное издание «Страховых законов штата Калифорния».
If you don't believe me, go to the source, the 5 volumes of California insurance law.
Я не сомневаюсь в том, что у нас существует коррупция.
There is no arguing that corruption is endemic in Russia.
Не сомневаюсь в том, что существует коррупция в судах.
I'm quite sure that there is corruption in the judiciary system.
Это, кстати, самый страшный вид коррупции.
And this is the most dangerous, the most ghastly form of corruption.
Вас возможности защиты.
Because with the judiciary system being corrupt, you are totally naked before no protection.
Но у нас существует 10 федеральных судов.
But we have 10 levels of federal arbitrage courts.
Это практически самые высокие инстанции. Дальше только высший арбитражный суд.
We are talking actually about the highest arbitration courts because above them is only the Supreme Court.
Сегодня все их решения опубликованы, публикуются.
Today, all their awards and rulings have been published and are being published.
Это несколько сот тысяч решений, которые вы можете сегодня найти в информационных базах.
We are talking about hundreds of thousands of decisions and rulings that you can find in databases.
Ну, кто-нибудь, кто так говорит легко о судебной коррупции, нашел 100 решений и сказал, вот они настолько нарушают судьи здесь закон, что они получили за это деньги.
I wonder if anybody delved into those hundreds of thousands of rulings and found 100 rulings that would be glaringly, obviously corrupt. Yeah, but if we're only speculating about the issue, yeah, I agree that corruption does exist. Thank you.
Louise, do you have anything? You had said that you guys had done some evaluations of decisions. Have you looked at these arbitrage court decisions at all?
There's some material. Maybe, Ethan, do you want to say something more on this юридическая практика? There's some analysis of both court and some arbitrage decisions. And one of them, but this was only for the St. Petersburg region. But there was some findings in the analysis that there was inconsistency, and there was a problem also in the beginning of collecting some of these judgments because they didn't want to have them overseen.
There was a question in the back.
Back to Kozyr. Is this trial of Kozyr the end of the argument against the oligarchs, or if the government is successful, which I think they will there be further prosecution against oligarchs and sub-oligarchs and even in absentia?
Get out our crystal balls here.
Well, all one can say is that the meeting on March 24th, Putin and a group of leading business people that Professor Markowski just alluded to is supposed to be a promise that there will be no more. But good analysis suggests that you can't tell, and you don't know what the conditions are. I mean, one report on this said this. Well, first of all, this won't affect any cases that are already have begun the court process, and secondly, who knows if some glaring scandal emerges? If there, you can't be sure, but it sounds like a temporary halt, at least, to this kind of thing.
There's a question right in the middle here. Yeah.
Hi, this is Bill Barlow, East-West Trade Development. For many years, I've been engaged in trade with the Russians, between Americans and Russians, and I notice that in every single transaction, they have their own interests. Some are mutual, some are conflicting, but they work them out and do not allow the other guy to take advantage of them, and they don't rely on law. They just plain work things out to their mutual agreement and understanding, and therefore, in the predominance of cases, there's no legal problem.
Well, I think most of the people that have studied the American system would also say that's true, that in most cases we try to work out the problems, that going to court is a last resort, and I think that's absolutely true in Russia as well, that it's a failure. So I'm agreeing, yeah. So other questions or comments? We can't be out of gas. Yes, Bill. Bill's going to get us started again. Some other provocative question for us. Oh, you're going to read from a book.
No,
excellent.
I'm going to read
Bill's
from my
have
book.
To read from Bill Butler will have to read from his book now.
Well, I noticed that Bill held his book up all during his session, whereas I at least laid mine down. But the issue, just a technical point. Someone raised something about the formation of a business enterprise for purposes of evading taxes, and Articles 173 of the Criminal Code, at least, has lже предпринимательство, which I translate as false business enterprise. And it sounds pretty broad. It says that the formation of a commercial enterprise without intent to carry on any business or banking activities with the goal of receiving credits, avoiding taxes, or receiving any other financial advantage, or concealing unlawful activities causing large-scale injury to citizens, organizations, or the state. Doesn't a holding company violate that? Or if you incorporate in order to get a lower tax rate? It sounds pretty broad to me, but I was just wondering if anyone knew about an actual prosecution under that provision.
I don't know. I don't know of any prosecution. A second question, which is a very complex question, maybe Oksana could answer, is to what extent should you read that as overriding provisions of the tax code where there's a conflict between them? And I think that's a very interesting question.
My first reply will be that I think that the provisions of the criminal code you cited are mostly preventive in their nature. I never met the case of such nature in the courts. Maybe I'm not, I was not in a very deep search, but at least in Moscow region, I haven't seen these provisions to be really used. And as to the taxation legislation and its relation to the other legislation which will prevail, I would say that from the perspective of the state bodies, the taxation legislation and the budget legislation will prevail over all other legislation of Russian Federation. If you are the other side of the dispute, you'll have to prove that your position also is relying on some legislation, and I wouldn't say that always the state will win. But in any case, they force their understanding that the budget and the tax codes are the best codes in the system of the codes of Russian Federation, until now at least.
Первым признаком коррупции в судах является незаконность решений.
The first indication of judicial corruption is if the rulings run counter to the law. In Kazakhstan, we also started the practice of publishing all court rulings.
Судьи — наиболее квалифицированная юридическая часть у нас среди юристов.
Among all the lawyers, the judges are the most qualified cohort. And judges are adept at masking the illegality of their rulings.
Общественных сил, оппозиции какой-то, правовой журналистики, научных сил, для того, чтобы разоблачить эту незаконность, проанализировать, у нас не существует. В Америке такой контроль есть над решениями.
And unfortunately, they cannot be exposed because we don't have, say, legal journalists and other societies that would supervise the decision, the rulings of the court and expose them if they're fraudulent. So the question is, do Americans have such a system that would allow to provide oversight over the corrupt courts?
I might say one thing on that. I have a colleague who initially studied to be a singer in grand opera and thus learned Italian, French, German, and even a little Russian. Instead, she decided to go into comparative law, using this excellent base in international culture. And specifically, she has done research on detection of corruption. And one of the things I've heard her talk and seen her write about is the fact that in the United States, our legal system is much more open to sting operations, where people offer bribes, where the FBI offers bribes to judges to see if they will take them. There was a very successful such operation in Chicago about 20 years ago, where a huge number of judges took the bribes and were arrested. Continental European legal systems generally have rules such as every crime must be prosecuted that make it more difficult to conduct a sting operation, and they often lack a tradition of sting operations. And my personal opinion is, without sting operations, it is very difficult to catch corrupt judges. I think judges don't like sting operations because it's rather easy to catch them that way, and this is a problem. Similarly, we were talking in our panel, can businesses survive if they obey the law? The FBI set up a bar in Chicago, and it bribed the liquor inspector, and it bribed the fire inspector, and it bribed the sanitation inspector, and every single public inspector who came by took a bribe, and then they were all arrested and put in jail. So this system works, but I think there are issues about using it in legal systems that aren't used to it.
Well, he'd also asked the question about the press, and I think it's fair to say that there's a very active legal press in the United States, but it's a very hit and miss kind of operation, that if they get interested in a certain topic, they may publish an investigative piece about it. But of course, they have no right to do anything more. They're doing it in order to bring it to the attention of the prosecutors, and then maybe there would be some effort to put forward a sting. And of course, we have the institution of court TV, right, which is... I'm sure you're all wishing you had that in your part of the world. So, but it can be. Peter thinks it's boring, but it can be boring. Yeah. Sarah's been waiting a while. Did you have a question?
I actually just had two brief comments, partly following up on Peter's "every crime must be prosecuted" and Bill's question about false entrepreneurship. One is, I actually have seen a number of cases of false entrepreneurship. I'm doing some research at the moment on criminal regulation of business as opposed to administrative or executive regulation of inappropriate business behavior. But all of the cases that I've been able to come across would also fall under fraud statutes. They're cases in which a business has been formed purely as a shell for the purpose of receiving credit from a bank or another entity, and then fraudulently refusing to pay the credit back. So you would not, in fact, need the false entrepreneurial...
Hold the microphone closer to your mouth.
Oh, sorry. In fact, you would not really need the false entrepreneurship charges here. You could simply have prosecuted these cases under pure fraud. But they are, in fact, there, at least in a few cases. I haven't yet seen one that looks anything like the situation that Bill described. The other point I just wanted to make on our closing off the Chodorkovsky debate, although I usually don't want to bring that back up again, and that is that there is a difference between reducing the statute of limitations on making contracts null and void because they were illegal and reducing the statute of limitations on criminal prosecutions. The two are quite different. So a promise to say we're not going to reopen privatization transactions, we're not going to pull apart another company like Yukos, is not necessarily a statement that we will not prosecute someone that we believe to have committed a crime. For some time now, Yabloko and a couple of other political forces have been pushing the idea of closing this off, getting a statute of limitations on the privatization process to have so-called security and property so that you can move forward in the business community. They have always been in favor of making an exception for serious crimes, that this does not include serious crimes. So there is actually rather a hole here for dealing with individuals that you think have been involved in serious crimes, fraud, threats, various other kinds of things.
Harley has a follow-up on this, and then I think Louise, right? Yeah.
Just to, one thing to add on that, there's also a question about whether this legislation or this change would have pertained just to the privatizations of 92 to 94. Most of the real money was made in the loans for shares, and that could be considered to be something other than a normal privatization.
Right, right. Louise? Yeah, and then in the back.
I was hoping Oksana could talk a little bit more about the differentiation you made between different sectors of the economy and the possibility of doing business honestly. And you drew a differentiation between publishing and auditing and the natural resource sector. And some of us in our research in the 1980s used to talk about differentiation of sectors depending on state interest. And I was wondering if you could expand a little bit more on that, and also talk about the possibility of doing business honestly in the service sector, restaurants, others, hotels, other sectors that have highly criminalized in the past in Russia and criminalized in our society often as well. Thank you.
At first, I would like to say that there was no strict scientific research undermine putting this business into two groups. It was just there looking into the profitability of the business as the main principle of their spread into two groups. As to the business of restaurants and hotels, you say it is being a bit criminalized. I think that yes, it's still a bit criminalized business in a sense, but the main problem of this business of restaurants and hotels and other services will be the starting of the business. And this point of the starting of the business, they will definitely need premises, they will need land lease and some other things for starting efficient business. And if they pass this first step, obeying the law or disobeying the law, the other continuation of the business will be much simpler. So the main problem of whether they can obey the law is on the first stage when they establish the business. And I would say that in Moscow, in St. Petersburg and other big cities, is the problem of whether they have enough money to make it legally, or if they have less money, then it will be cheaper for them to make it illegally, because the cost of the lease of business premises in Moscow will be very high. If they have this money to be put into the business, they can do it legally and easily can do it legally. If they don't have enough money, the chances become much bigger, then they will have to use their other possibilities to get the premises they want, for example.
Thank you. We had a question all the way in the back.
I was hoping Professor Maggs could expand on the proposition that it's easier to do sting operations against judges in the U.S. than, I take what you were saying, elsewhere generally, but perhaps especially in Russia. Why should that be, apart perhaps from lack of honest enforcers in other places?
Well, as I understand it from my colleague, who is the expert here, I never studied grand opera, so I'm handicapped in Western European languages. There is a strange feeling in many continental European countries, one, that government officials should always obey the law, and two, that violations of the criminal law should always be prosecuted. And if you have these strange prejudices, you can't do a sting operation, because if I buy drugs from a drug dealer, I'm disobeying the law on buying drugs. And if the prosecutor doesn't prosecute me, the undercover cop, the prosecutor is not prosecuting the crime. The United States does not have those strange prejudices.
Italy has the most prosecutions. Not all countries in Europe, but certainly some.
they have,
that's one of Jackie's cases.
Her particular field of study was Italy.
Some Germany. She did some stuff in Germany too.
So that makes sense. Yeah.
But they've made some special exceptions by statute in Italy.
Okay.
But other countries haven't made special exceptions by statute.
Right. But one of the points of her research is how difficult it is to do joint operations, and how Americans can get in trouble overseas because they don't understand these rules. Right, Peter?
And every country has different rules.
Right.
One country lets you do things A, B, and F, and another lets you do things B, G, and H, and they're different.
Yeah.
So
I mean, one of her arguments is that this makes it very difficult to engage in the kind of joint operations that we often hear reference to in the popular media, that the details of the criminal procedure codes can make it very difficult. Yeah. Bill, do you have another reading for us?
Actually, I do, but I did have a response to something relevant here. The issue of sting operations is currently being debated in Georgia, where I'm working with them on the Criminal Procedure Code, and I think a large part of it is the notion that everyone who is guilty should be prosecuted, but also everyone who did the crime should receive punishment. And it's very difficult to promise as a prosecutor, well, if you roll over on Mr. Big, then we will make a recommendation on sentencing, or the judge will indicate an agreement on a lesser sentence. And unless you have that tool, then you're not going to have people informing on the next person up. And that is a serious problem in the Russian code. Even when they adopted guilty pleas, they adopted the Italian system of you get a 1/3 discount, period. If you plead guilty, and you don't get a discount for anything else. And it's a strong, I think, continental mistrust of prosecutorial discretion that leads to that. But obviously it's very difficult to do that. On the same point, I remember at one point being on some consulting delegation or something on a country where we're supposed to look at the issue of corruption. And it seems simple to me, Western assistance to ferret out corruption and give them eavesdropping materials and eavesdropping devices. I wasn't asked back after I suggested that. Instead, they held a conference on corruption to discuss it. But it seems to me that the route to clear cases of corruption, there are ones where you can say, well, is it corruption, is it not? Clear cases of corruption is pretty clear, and people know how to ferret it out. The only question is, do they have the political will to do it? The other comment I want to make about Khodorkovsky, if I might, that many people complained about the Khodorkovsky case largely for violating the standards of the new Criminal Procedure Code. And I happened to have been there during the markup on that, and we were working on the stuff on pretrial detention, which I think is probably the most common complaint in Khodorkovsky. Why is he sitting in jail? Why wasn't he released? And the language that we arrived at was that that a person can be detained physically if it is impossible to assure his attendance by less restrictive means, which is a pretty strong statement. So people have taken that as an indication that the Russian judges just don't follow the law. Later I was at a discussion of this issue, and some of Khodorkovsky's 340 defense counsel were also there, and one of them said, now, if Mr. Khodorkovsky it's proof that he's not guilty, because if there was any indication he was guilty of anything, he would have fled. That to me maybe supports the decision of the Russian judge. That tells me that if he thinks he's going to be convicted, then he's out of here. And so I'm not sure that perhaps the law wasn't properly applied to Khodorkovsky, where you can buy a plane and leave anytime you want.
Is Keith Ralston. I wanted to change the subject from Khodorkovsky to Yukos. No, I mean, there's been a lot of discussion about Khodorkovsky, but there's been very little discussion, and I'd like to hear from the panel on the Yukos case and the sort of the belated filing of these old tax bills, and basically, essentially, at least from some commentators, reprivatizing, or to make Yukos a public company, to remove the assets from Yukos and give it to a government entity. And I wanted to find out what your thoughts were on that. Thank you.
I've had access to some privileged lawyer-client communications in Yukos, therefore I can't give any comment.
I would speak not because I'm afraid of speaking on it, but because I don't know what's going to happen really. They can take these assets, but why shall they do it? Legally, they will have some methods. You see what they have done with the daughter company. It was legally done very clearly. So we shall wait and see what's going to happen.
Maybe you have some wisdom to add to us, Keith. I mean, what do you
Maybe
think?
you're working for the government side in this case, no?
No, I wish I had some wisdom on it. I think it's to lay people as if they've used or misused the tax code to basically to shift assets from the private sector to the public sector, and it's it's a device used by some very talented government lawyers to extract the assets from Yukos and give it to the government or government-held entity.
Right. Louise, did you want to comment on this? Oh, Bill, did you? Yeah. Oh, Bill was an expert witness in the Yukos case, so he will share.
Yeah, maybe.
Partly I have Peter's problem, and I'll walk around that one. Before I even address it, though, let me return to the sting question, simply because those who want to follow that should look at the Article 450, approximately 460 of the Customs Code of the Russian Federation, and you'll find that it authorizes test purchases, including of narcotics. In the new code, it has been broadened beyond narcotics, and it deals with test purchases of other things that might be criminal in character. So it's there. It came in partly through foreign assistance, in this case through Scotland Yard, and British experience with projects of this nature. I can only respond very generally about Yukos, but let me do it in the form of questions and suggest that perhaps it might help direct your thinking. I think you need to ask yourself whether execution against the stocks of Yugoslav was in fact a form of nationalization, expropriation. You choose one of the 11 words in the Russian language for forms of taking, or whether in fact there really was any serious element of state ownership of the stocks, however briefly it may have happened. I think if you move along those lines, it may lead you down lines of inquiry that change the configuration of the questions.
Well, that's nice and cryptic for us. We can all spend the weekend pondering that one. So, Louise, did you want to comment on this?
I was saying I see this in this paper more as a, well, to me, in something else I've written on this, that there's no, this one's right and that one's wrong. I mean, it's all so murky, as Peter was saying, and the rights and the norms. But it's certainly political use of the legal system, which we all agree on. But it's one of the questions that comes, and its influence, I think, that we haven't talked about enough, of can you do business, is the impression it gives about shareholders' rights, about who your business partners are, whether you can have long-term relationships with them, and what kind of business environment. And the question comes in looking at this of, if you have so few large cases like this, then, for an outside investor, what brings somebody into a targeted prosecution? And to say that this is the end, there are people outside of Russia today that the Russian government is seeking to extradite to prosecute. I can think of Patakashvili in Georgia. I can think of others. And so there is a possibility, if people do not perceive this as being a political process but a criminal process, that others can follow, because criminal cases have been initiated by people who against people who've already left the country.
Mm-hmm. Yes, good point. We're just about out of time. I think we have time for perhaps one last question if anybody has something that's burning that they must get off their chest. Perhaps not. Perhaps everybody's ready for the reception. So let me invite you to join us in the reception. It's over in the boardroom. Is that right, Joe? So you can just go out and sort of follow the path over to the food. Thank you very much.
On champagne.
Yeah, yeah.
So you got a good discussion going.
Yeah.
Actually, I understood what happened with UCAS. As optimization of taxation can go too far and turn into criminal affairs, then optimization of consequences